So, good evening and welcome to this webinar on recent developments in Olympus Spa, the Armstrong. My name is Irene Lawrence. I'm the Public Actions Coordinator with WDI USA. So if you need a quick refresher on what this case was originally about, it involves a man who calls himself a woman who insisted that his human rights were being violated when a female-only nude Korean spa excluded him. He complained to the Washington State Human Rights Commission and won, and the spa fought back with a federal lawsuit. In April 2024, WDI USA filed an amicus brief in the case. Our brief supported neither party as we did not agree with the spa's religious liberty arguments, and we wanted to keep it focused on women's rights. The brief made three arguments. If the Washington law against discrimination elevates gender expression or identity over sex, it violates the Equal Protection Clause of the 14th Amendment. But the WLED also protects sex by exempting lawful classifications that are based on sex and necessary for sexual privacy. Two, Washington state cannot practically enforce both gender expression or identity provision and its criminal laws prohibiting voyeurism and indecent exposure. And three, the district court used the term transgender and other related phrases uncritically in its written decision. So that was the main gist of our brief. In November 2024, when oral arguments occurred with this case, myself and several TERFs in or near Seattle, including Kara and others, organized and hosted two events in conjunction with these oral arguments, a panel discussion and also a rally outside the courthouse. On March 12th, 2026, the SPA's motions for rehearing were denied. This didn't surprise us, but we were pleasantly surprised to read the dissenting opinion of Judge Lawrence Van Dyke, I think, who cited our brief 4 times in his dissent, marking the first time WDI USA has been cited in a federal appellate opinion. His epic dissent begins with the phrase, "This is a case about swinging dicks," and it only gets better from there. Olympus Spa's lawyers have announced they will ask the Supreme Court to take up the case, and they have invited WDI USA to file a brief in support. We are considering doing so, but we need your help. We are an all-volunteer organization, and filing briefs is a key way that we are increasingly able to influence law and policy. But these briefs are very time-consuming and expensive, so please consider starting a monthly contribution to fund our work in this area, or if you are already a monthly donor, thank you so much. Every little bit helps. Right, I'm excited to now welcome our panelists, Elspeth Cypher, retired Massachusetts Supreme Court Justice and Wolf Board President, and Kara Dansky, former WDI USA President and the author of WDI USA's brief in this case. Go ahead.
Did you want me to just go ahead and start?
Yeah, go ahead.
Okay. Hi, everyone. I'm Kara Dansky, former president of WDI USA, as Irene said, and I was the initial drafter of the brief that WDI USA filed before the Ninth Circuit back in 2024. Just to add a few things to what Irene said, as she mentioned, this case involves a man named Haven Wilvich. His original name was Caleb. And at some point, he decided that the Olympus Spa was violating his human rights, AKA his rights under Washington state law, the Washington law against discrimination, because it had a female-only policy. He brought the spa before the Washington State Human Rights Commission, and he won because of the way in which state law defines the phrase sexual orientation to include the nebulous phrase gender expression or identity. So then, as Irene said, the spa sued the Washington State Human Rights Commission in federal court, the United States District Court for the Western District of Washington, and the spa lost again because of how the courts are interpreting state law, which again defines sexual orientation to include quote unquote gender expression or identity. Now, the federal district court, the Western District of Washington, I have to say, used the phrase transgender women with male genitalia repeatedly and uncritically throughout its decision. And that's the first and to date only time I have seen the phrase transgender women with male genitalia in a federal court opinion. And so when the case went up on appeal and WDI USA wanted to file a brief, I realized I was going to have to explain to the Ninth Circuit Court of Appeals why that phrase was so problematic. And so I had to track down a citable definition of male genitalia, which I did. I found an accurate definition from the National Institute for Health, and I put it in the brief. And then I found myself thinking to myself, why do I have to be talking about male genitalia in a United States court brief? And I followed that definition by saying it should go without saying that women do not have these organs. And then that paragraph of our brief concludes with the sentence, "It is truly a testament to where we are as a society today that it must be said in the context of federal civil rights litigation that women don't have penises." That sentence appears in our brief. And to the best of my knowledge, that's the only time a sentence like that has appeared in a federal amicus brief in support of feminists. So, as Irene said, we filed in support of neither party because the SPA's lawyers, who are members of a Christian conservative organization, filed a brief that focused almost entirely on the SPA's First Amendment right to religious liberty and to speech. And as Irene said, we wanted to keep the brief very focused on women's rights. The Ninth Circuit came out with its opinion in the middle of 2025, and it ruled majority 2-1 in support of or affirming the district court and against the SPA. And the Ninth Circuit, like the district court, ruled that Washington state law allows men who have woman gender identities to be in what are supposed to be female-only spaces. But part of our argument was that it's not necessarily wrong because of the terrible way in which the Washington state law against discrimination is written. So as bad as this Ninth Circuit decision was for women and girls, and it was not necessarily wrong under Washington state law. This was an outcome that we anticipated when we filed our amicus brief, and we issued a statement shortly after the Ninth Circuit decision saying that we anticipated it and we understand why the Ninth Circuit ruled the way it did. I think we'll get back to the more recent decision denying rehearing. But in the meantime, I would be very interested in hearing from Elspeth as a retired appellate justice. Is there anything the Ninth Circuit could have done differently? Is there any way the Ninth Circuit could have engaged meaningfully with the feminist arguments that WDI USA was putting forth?
First, thank you for inviting me over from the other side of the internet, from Wolf to talk with you at WDI. That's a big question for me that when I first thought about that question, it's like, well, yeah, they could have engaged with your arguments, but also, and so I want to just start with the way they handled this, the majority. If I were doing it, and I think if most of my colleagues were doing it, I hope at this point still, you don't have to go far in this case to resolve it if you're going to accept the premise that the statutory interpretation is okay. And that gender identity is like a sexual orientation. All they had to do a better opinion overall is stick to straight statutory interpretation, which they claim they did. But Justice Lee, if you look at his concurring or dissenting opinion, I forget how he framed it, he did I think, a much better job on statutory interpretation, because the whole question was, as you said, about that gender identity, gender expression, and whether that fits into sexual orientation and all that. And he said, look, you've got to look at that in the whole context of the whole statute, and it's illogical. So it shouldn't apply. So that's what he did. But if he would have said there was, that it was not protected, is what he would have said, just as a matter of simple statutory interpretation. And if you only do this case on statutory interpretation, which they could have done too, even under their stupid under their majority opinion, which I don't think is very strong, you don't go any further. You don't get to the religion case. You don't get to anything. You just have a simple, clean opinion. You might disagree with it, but it's not going to, cause controversy. The other way I think they really, really erred was in engaging with Justice Van Dyke's opinion. All they had to do is ignore it. He was provocative with his opinion. I personally appreciated it a lot. I'm sure many people actually did, because it's so, when you talk about this topic, it is so, in legal terms, you never really get the shock that the women get in the public space. But he gave that to everybody. And that's what he did to all those judges, so that they ended up, I think, feeling how many women have felt. And so from where I'm sitting now, and even if I were on the court, I would say, yeah, you go. It got it in their face, so to speak. And they all reacted very badly, I think. They just needed to ignore him, and then he would have looked out of place, right? You didn't have to write, we can be better than this. You didn't have to do any of that. You could just skip it.
So I was thinking we were just at the panel stage.
Oh, I'm sorry.
That's okay. No worries.
Did I do it?
I was thinking we were just dealing with the 2025 Ninth Circuit panel decision before getting to the rehearing, because that.
Oh, I'm sorry. Okay, yes,
okay.
I misunderstood that. So I'm not as intimate with the case. Your first argument was equal protection, and by that, they could have easily, I think, handled that easily, in favor of the women. Because first you would say, okay, they do a little statutory thing, say, yeah, gender identity, no, women, sex, equal protection. You're right, WDI. This does violate and harm women and girls' rights to privacy. And it would have been a landmark case, because it would have said that. It would have said we have rights and privacy in locker rooms and spa rooms. So it would have been a really big step. And if they were applying equal protection, I think they would have applied what we know as the intermediate scrutiny test, which is what is applied when women are, when the issue is sex. There's three, one, two, three. There's rational basis. If it doesn't affect anything big, then there's intermediate or heightened scrutiny if sex is involved, and then there's strict scrutiny if it's race or ethnicity, and sometimes free speech or religion cases. And intermediate scrutiny works for women, I think, because it takes into account sex. If we just said it was strict scrutiny or equal protection is the same for men and women, then what happens is, well, we treat men the same way we treat the women. So as long as the men are treated the same as the women, there's no distinction, there's no discrimination. But I think they should have engaged with your argument. You had a good argument there, and it would have been a landmark opinion. And I don't see any reason why they could not have done that, except for the fact that hadn't been being raised. The second argument you had was that it's a crime, which is interesting. I see this more as a defense to a crime, like somebody's charged with voyeurism or exhibitionism, and then or open and gross or lewd and lascivious behavior, and then the defense attorney runs in and says, hey, it's a-okay in the spa, it's a-okay on the beach. But that, I think, you could argue it's circumscribed by location. I think in Nantucket, Massachusetts, there's an ordinance or something that permits women to be topless on the beach, but it would not permit that in other locations. It would need to be limited in terms of its location. And then finally, on terminology, you raised a really, really good point about let's deal with the language and how nothing is defined, and start defining some of these words. Just get them in writing, because they aren't anywhere solid as far as I can tell in the cases. And we need a definition of sex. We need a definition of gender identity. It's a good breed, I thought.
Oh, well, thank you very much. As far as I can tell, neither the two judges in the majority nor the one judge in dissent engaged with any of our arguments at all.
No, they pretended you weren't there.
Yeah.
Just
So,
like they pretended the other guy's a man. That penis is female.
yeah.
They just ignored it.
Okay, so shifting now to the rehearing motion. So the Ninth Circuit panel decision came down in mid-2025, and the plaintiff's lawyers moved for rehearing either by the panel or en banc. Do you want to explain what those things mean?
Sure. Rehearing is when a party asks the court, could you please take a second look at this because you've made a mistake, basically. And usually those are not successful unless in fact they did make a literal mistake and they correct it. Fine. En banc is when this is an issue that is so important, so contentious, so controversial. We really need to speak with the whole court. The whole court needs to hear it. Now, there are, I think, 50 some judges on the Ninth Circuit. So getting them, you can't just bring them into a room and say you're having court. You can do it on Zoom. And I'm sure there are plenty of other ways they can manage this in terms of panels and report and documents and things like that. But had they had the rehearing, it would have been all of those judges having to make a vote. As it stood, most of them voted against rehearing, even the judges that weren't on the panel. But I think about 22 or so of them didn't even bother to register a vote one way or the other on whether to hear the case. So that's telling me they're really checked out on it. It's like they don't care. It doesn't apply, or they think this will never happen. And why do I need to bother filling out the piece? Or I'm so frustrated with the federal courts, how slow they are. It's still sitting around waiting to be looked at by somebody because they didn't get to it in their chambers. Probably the most likely thing. So and then those are rare, very rare, but when they are granted, and when they are heard, and it can change the direction of the case, it can change the outcome, can change the reasoning, it could reach out and bring in your brief. It could have done all those things if they'd voted to hear it, which I think this one deserved rehearing.
Yeah. Okay, so we know now that the majority of the Ninth Circuit declined to have a full court rehearing, and there was this dissent by Judge Van Dyke, which Elspeth has already referred to. Is there anything else you want to say about his dissent?
I think his dissent, in my view, I read his dissent as he was calling them out, basically, for not looking at anything really, and for not facing what was in front of them, and for not dealing with the real issue, and for hiding behind, legal language or twists and turns and things that make it very difficult for people to understand what they're talking about. They did not write this case in plain language, which is something I think we all should be aspiring to. They wrote it in legalese with twists and turns and sleights of hand, so that, by the time you're finished reading you're halfway through the majority opinion, you haven't really noticed that they actually did the statutory interpretation wrong according to statutory canons. So they, decide, oh, that's not ambiguous at all. Everybody knows what gender identity, it means sexual orientation, and this is obvious and it's perfectly clear, when it's not. It's just, we all know that. So I think he was very good at calling people out.
Yeah, great. And the other thing he said that was very meaningful to me, when I first looked at Judge Van Dyke's dissent from the decision declining to rehear the case by the full court, and it said, this case is about swinging dicks, I will be honest with you, I was horrified. I was horrified because this is language unbecoming the federal judiciary. But the very next paragraph says, and this is Judge Van Dyke addressing the judges in the majority who did what Elspeth just said they did, which was obscure everything. He said, and I'm paraphrasing here, if you are upset at seeing the phrase swinging dicks in a judicial opinion, imagine how appalled and disgusted actual women and girls are at having to see the real thing in what is supposed to be a female-only space. And when I read that, I could see his point completely. And I was so grateful that he did what he did.
Yeah, I think that was a good move on his part. And he you get the point at that point. You just get it. And I don't think any readers could not understand the case if they just read his opinion. So I also thought Judge Lee did a good job, a better job in the original opinion. So anyway, yay for swinging dicks. And this is something I think we shouldn't be afraid to do. And we do it sometimes in our briefs at Wolf, which may be why we aren't cited as much as you are, Kara, or at all. But I believe in showing the judges verbally, if you have pictures with pictures, showing them what we're really dealing with. Because there's a part we recently had, we've been doing prison litigation at Wolf, and Chandler versus what was CDCR is now renamed Macomber. The judge, after like a year and a half or 2 years, finally issued a decision on a motion to dismiss the complaint, but said we could file an amended complaint. And the way there was such a condescending tone in the opinion, for one thing, and the sheer, just like, women don't exist, actually. It's how it reads. So I feel like we're already being disappeared in the language. And right now we have to analyze that decision and figure out whether we're going to appeal or whether we're going to file an amended anything or file for rehearing. But it's just so disheartening that they don't recognize this inherent harm. And to me, that's representative and reflective of the basic inherent misogyny in our country and in our law and in our minds. I don't see it.
Yeah, we are definitely here to discuss Olympus Spa, and I want to talk about next steps. But I also will just respond to you, Elspeth, and say that I reviewed the dismissal of the Wolf prison case, and one of the most frustrating things to me was that the order dismissing the case literally contains language around what the incarcerated women are saying have been done to them. They are talking explicitly in the complaint and other legal documents about being sexually harassed and abused by incarcerated men in the women's prison. And then the judge basically turned around and said, there's really nothing actionable here. The women haven't alleged any concrete harm. And it's like, did you read? I read that. I read what the women said about the harms they have suffered. And he's just like, yeah, I don't really see it.
Yeah, worse, it's a she.
It's a female judge. Oh. Okay, so next steps with Olympus Spa. Feminists are in a real bind here. And Elspeth and I have been in conversations behind the scenes about what to do. Here's the reason we're in a bind. The spa's lawyers initially brought exclusively First Amendment claims. I don't want to say that those claims are unsympathetic, because I am very sympathetic to the First Amendment rights of women to speak out about what is being done to us. And although religious liberty is not my primary issue, I do certainly care that people have religious liberty. And at the same time, this spa is a place of public accommodation. And the argument being made was that because the spa owners are Christian, they have a religious right to exclude men. Not a big fan of that argument because I think any female-only space should be able to exclude men for any reason. Nonetheless, those are the issues that were brought by the spa's lawyers. Those are the issues that the district court, the lowest court in the federal system, decided. So when the case went up on appeal to the Ninth Circuit, that's why WDI USA ended up filing in support of neither party, because those issues were not the issues that we wanted to raise. Now, where it stands is that, as Irene initially said, the SPA's lawyers intend to ask the Supreme Court to review the case. It's the mechanism for doing that is called a petition for certiorari, and the SPA's lawyers will most likely file it, and they will most likely file it on the same First Amendment issues. And then feminist groups are going to have to decide whether to weigh in on that question. The reason that's difficult is that at that stage, we don't have the option to file a brief in support of neither party. We only have the option to file either in support of the Supreme Court taking the case or against the Supreme Court taking the case. Here, there are very good reasons for this Supreme Court not to take the case at all. And so one consideration is, do we file a brief in opposition to the Supreme Court taking the case? And if so, how do we frame the feminist arguments? How do we get the feminist arguments before members of the Supreme Court? And it is not at all obvious how to do this. And there are some very smart lawyers who are talking behind the scenes, who are engaged in some very lively conversations, many of them very collegial, many of them very fiery and oppositional. And it's not at all clear what the best next step is for protecting women and girls in the law in the context of this case, which is not a great case for feminists. Elspeth, can you add to that?
Yeah, I would just I agree with that. It's really hard to decide what to do. I'm, and I go back and forth. Sometimes I think, yeah, file something that says for neither side, and this is why, and let them all have the good, strongest feminist argument we can make, or you could make. And then I think, well, maybe we should pretend the case doesn't exist like they pretend we know we don't exist. But so I do, and even if you file and they grant cert, say they grant cert, and now you have to file, whether they reach and take a feminist argument would be interesting. They might take a woman's rights argument more than they'll take what we call a feminist argument. So, maybe they'll look at it that way. I think at this point, we have got to start focusing more on the sex-based cases, because there's been so much activity in the Supreme Court. Well, the sports cases are coming, so thank goodness for that. Maybe that will send some light. That's a nice sex-based case. But we've seen, so many religious issues, and we've jumped on and filed briefs in some of those to present the feminist side. But that seems well in hand now. Scrimetti came out, and everybody's suing everybody, and places are closing. So let's start focusing back on women and girls and their sex-based rights and right to privacy, safety, and dignity, and make that bedrock somehow, because it's very slippery at the moment.
So let's just quickly clarify, because you threw out the sports cases and Scrimetti. So for anyone who may not know, Scrimetti was a case about a Tennessee law that banned puberty blockers and opposite sex hormones for minors. And a group of minors and their parents and a doctor sued the state of Tennessee, arguing that the Tennessee law violated trans children's right to equal protection under the law. And I forget what happened at the lowest court level, but on appeal before the Sixth Circuit came out with a very strong ruling that it's perfectly constitutional to ban puberty blockers and opposite sex hormones for minors. And then the case went before the Supreme Court, and the Supreme Court ruled similarly. The Supreme Court's opinion is not great in my view because it doesn't provide any clarity into what the word sex means, but it's still a good ruling in support of puberty blocker bans. And then
Right.
the sports cases are two cases, one out of West Virginia and one out of Idaho, involving state laws that protect female-only sports in schools throughout the states. In both cases, male athletes sued their states. In Idaho, the male athlete won at the district court level. In West Virginia, the male athlete lost at the district court level. They both went up on appeal, and both male athletes won at the level of the federal appellate courts. And both states asked the Supreme Court to get involved and review the case, and the Supreme Court agreed to do so in both cases. Oral arguments were held in January, and a decision is expected this summer, and the sports cases squarely address the question of what sex means and whether women exist as a coherent category.
I sure hope they address that. I really do.
So yeah, so on the Olympus Spa question, the question of what to do for next steps is not at all an easy one, and many of us are grappling with it behind the scenes. So Irene, do you want to follow up with any of that, or do you want to ask us questions, or are there audience questions?
Yeah, there's a few that have popped up in the chat as you all were talking. So yeah, Carrie asks if the spa is allowed to change their argument in its appeal to the Supreme Court, or would they be required to start over? Similarly, Christy asks, can we encourage the spa's lawyers to expand their argument as sex-based civil rights and female-only spaces on top of religious freedom?
I mean, Elspeth, I would really appreciate hearing from you on that because so it seems like Carrie's and Christie's questions are related in the sense that Christie's saying, can the spa's lawyers expand their
Mhm.
arguments? And Carrie's saying, can the spa's lawyers change their arguments?
Mhm. Yeah.
Those are both very good questions. And that's part of the reason we're having trouble deciding what to do. Normally, typically, procedurally, according to normal rules, the spa could not expand their argument in a way that changes it. And theoretically, an amicus is there to educate and help the court and maybe draw their attention to things they aren't thinking about. Like, a mild example would be when you get a land dispute, and then you get amicus briefs from the Conveyancers Association. Well, that's to me was always very helpful on the bench. So they can be very useful, and there is precedent for the Supreme Court. Look, they can do whatever they want. Let's just say that right now. If they want to do it, they can do it. If they don't want to do it, they won't do it. They can fight over it. They can dissent over it. They can split 6-3. Whatever they want to do, they can do on that. If they want to continue to follow court precedent and rules and regular procedure, as we would call it, then they can let the spa open up a bit. They might even write to the spa and say, hey, here's this issue we'd like you to address, and invite amicus. And so they could even insert the issue themselves. And an amicus can raise new issues. So certainly WDI can raise women's rights questions in an amicus. And yes, the Supreme Court, if they wanted to, could take it. They also could say, we don't take things that haven't been raised below. They could do either of those. And when I was in practice, this is a stupid aside, it drove me crazy that there were no clear answers like that. And then I got on the bench and I said, thank God we have 2 lines of cases going 2 different ways. Now I can do what I want. So
Great.
helps.
Sounds like that worked out.
But also, it would seem to me that the spa's lawyers are not particularly, So as Elspeth is saying, amicus can raise whatever we want, right? Like amicus, we're there to educate the court about issues that may not be obvious to them. It seems to me the SPA's lawyers are not going to want to expand or change their arguments, in part because they like their arguments, but also in part because it would make them look a bit foolish.
Mhm. Yeah, they should have thought of it before, if it was so important and good. Absolutely.
So this is maybe going back a little bit to earlier in the conversation. Lisa asks if someone's sexual orientation is adult baby diaper lover, would the Washington law force a daycare to enroll them if they had one of these alternative gender identities? Is,
I mean,
how
that's
broad is
such,
that law?
yeah, no, it's such a good question. And typically, these laws don't even define gender expression or identity. And if they do it in a manner that is completely circular. I'm not aware of anyone filing a legal action to protect adult baby diaper love as a gender identity or as a sexual orientation. But those of us who follow this stuff closely on social media know that people make that argument in society. I almost wish somebody would do that in the federal judiciary, and that might help these federal judges wake up to what is really going on here. This is not a civil rights movement. This is a fetish movement. And those of us on this panel and those of us watching know that. But the federal judiciary still doesn't know that. And we've done our absolute best. This is one other thing I wanted to say about Judge Van Dyke and his swinging dicks opinion. The Women's Liberation Front has been filing amicus briefs before the federal judiciary at least since 2016. WDI USA has been doing it at least since 2020. Both organizations have consistently used extremely professional, extremely calm language in presenting our legal arguments because we have to, because we're women and because we're, you know, TERFs. We have to dot all of our I's and cross all of our T's and be as careful as we possibly can in order to be taken seriously. And we've done that. We've done that for a decade now. And some judges on the federal judiciary have heard us, but for the most part, we've been ignored. And Judge Van Dyke just blew that out of the water.
Yeah,
It
it had
seems,
to be a man taking a stance like that
yeah,
with
that
that
was,
language. There was one question from Beth about the prisoner case. She says, "Where can I read about the case dismissal regarding women prisoners?"
I can get the link up or send you the link, Bev, to the case. We haven't written anything on it. It's in process right now. Like I said, we were trying to integrate it with what we decide to do. So they're going to come out at the same time. But I can send anybody the link to the case, or did I
Or
send
could
you?
you put it in the chat?
Got
Is
it.
there, yeah,
No problem.
um,
I'll do that now.
send it over to the group. And oh, this is the women's prisoner case in California, right?
It's Chandler
Chandler.
CDCR, which now is Chandler versus McComber. It's been going
Mhm.
for a while. We filed a complaint early of I don't remember what that was. It was before I was at Wolf. And then they dismissed that and said, but refile it this way. They give very, very specific roadmap. So, okay, we know we're going to follow that roadmap. And now they say, yeah, well, if they don't admit we followed their roadmap, but you didn't allege this and you didn't allege that. And they basically are saying the harms to those women were in the past. You haven't shown it's specifically tied to that bill, SB 132, that just lets men in on the basis of their saying they're a woman. Before that, maybe they had procedures. So if you can't tie it specifically to this law, you know, And you can't show that this prisoner wouldn't be there anyway from some other reason because they could do it before. And your future harm is too speculative. You can't show what I don't know what they want. It's clearly the problem is the harm comes from the men. I mean, so they even ignored that in that case that Tremaine Carroll had tried to intervene in our lawsuit and got in, even though he was being charged with rape while he was in prison in a women's prison. He was charged with rape there, and that trial's coming up in March, soon, not March. And so they know better. They know better. And nevertheless, it's a very strange opinion. And it's also full of twists and turns, which make it hard to follow. So, but I'll put that in, let me find that and put that in the link.
It is. Let me just jump in also and say, yes. So Elspeth has been talking about the California case. The Beth who's asking this question is a Beth who lives in or outside Seattle, and she's specifically asking about Washington.
Sorry.
No, that's okay. That's all right. It's great information. I do know that there is a case concerning the Washington state policy, which is very similar to California. The difference is that in California, this is all happening pursuant to a state law that was enacted by the state legislature and signed into law by the governor of California. In Washington state, the exact same thing is happening, but it's happening pursuant to Department of Corrections administrative policy rather than pursuant to state law. And Beth, there is a case in the works. I don't know where it is or whether it's been filed yet.
Yeah, and then somebody's mentioned Massachusetts. Things are going on in Massachusetts, but I'm not sure exactly what's happening there yet. We have women who need lawyers.
I don't see any other questions in the chat right now. Does anyone have anything else they want to ask our
I feel
panelists?
like we didn't talk long enough.
No.
Um, Holly
Well,
says it would be great to. Ooh. It would be great to hear some of the arguments being considered by WDI and or Wolf for amicus briefs on the petition for cert.
hey, Kara, do you want to take that while I look for my opinion?
Sure. So one of the arguments concerns equal protection. And when I say that, I mean the Equal Protection Clause of the 14th Amendment, which was ratified in 1868 in order to remedy centuries of heinous racial discrimination that had resulted from the institution of slavery. The United States Supreme Court decided in 1971 that women count as people for equal protection purposes. And between 1971 and 1996, and ongoing, but 1996 was a really pivotal case, United States versus Virginia, authored by the late Justice Ruth Bader Ginsburg. There's this vast body of case law protecting women and girls in the law on the basis of sex. And what WDI USA said in its argument, in its amicus brief before the Ninth Circuit, was that to the extent that a state law like Washington's law elevates so-called gender expression or identity over sex, it violates the Equal Protection Clause of the 14th Amendment. So that's one argument that could be put forth before in a brief before the Supreme Court on whether it should take the case. The question is less about what arguments to put forth, although there are people who disagree with me that it's a good idea to raise equal protection for very complicated reasons. A different question is whether to argue for or against the Supreme Court taking the case. This is such a bad case for the women's rights arguments in the law that we almost don't want the Supreme Court to take the case because, as we've seen from recent Supreme Court decisions on religious freedom cases, the current court is quite sympathetic to the religious freedom arguments, which is not a bad thing. It's just to say that feminists don't particularly want a Supreme Court opinion that says that places of public accommodation, like female-only nude spas, can have a religious exemption to keep men out. We want all female-only spaces to be able to keep men out. And so it was sort of one thing when the Supreme Court said religious parents have a religious right to get their students out of classes where gender identity is being discussed. The Supreme Court decided that not too long ago. But it would be very bad to have a Supreme Court decision saying that religious organizations that are meant to be female only can keep men out, because we think that any female only organization or business should be able to keep men out when it's intended to be female only. An entity that's intended, like the restaurant portion of a restaurant shouldn't exclude women or men, but the bathrooms should be able to, right? So we want to get this clarified, that throughout society, sex is real. Sometimes it doesn't matter. Sometimes it does matter. And when it does matter, we need clear laws explaining what sex means, who men are and who women are, and women's sex-based rights to single-sex spaces. And it's just not obvious how we get the Supreme Court to say that.
What kind of case do you think we need? What would it be? An employee situation, a woman at work going into the bathroom and being faced with men, or would that not get us there because it's going to get knocked away with Bostock and EEOC law?
So it will never not be frustrating to me that there was a case. Okay, let me back up. I like the sports cases a lot because they provide an opportunity for the Supreme Court to say that states are permitted to maintain single-sex sports throughout the state. That's great. What I don't like about these cases is that these are state laws that said single-sex sports only. And the challengers in these cases are male athletes who said the laws violated their rights. One thing that means is that the only question before the Supreme Court is whether these state laws violate the rights of male athletes to be in women's sports. The question of whether states are required to protect female-only sports is not currently before the Supreme Court, which bothers me. It's a drawback. So I say all of that to say there was a different case called Doe versus Boyertown, and this was a case that originated outside Philadelphia. There was a school district that decided over the course of summer 2017 that it was just going to make all of its bathrooms and locker rooms mixed sex. It didn't tell students and it didn't tell parents. It just said, we're going to do this. And so in the fall of 2017, it's very strange to me that I remember all of these details, but here we are. In the fall of 2017, a boy who was in court documents known as Joel Doe was in the boys' locker room, and he was standing in his locker dressed only in his boxers, and he looked up and he saw a girl. And he didn't like that. A lot of boys don't like this any more than the girls do. And a group of students, high school students, got together and said, we want to challenge this. We don't like this. Mixed sex group of students, girls and boys. And they challenged the school district. And the case went before the district court somewhere, Eastern District of Pennsylvania, I suppose. And then it went before the Third Circuit Court of Appeals. And the Third Circuit Court of Appeals ruled that it was perfectly fine for the school district to obliterate sex categories. And Wolf encouraged the Supreme Court to take the case in 2018. And it would have been a really good case because unlike the sports cases, this would have been an offensive case. This would have been students saying, no, we want single-sex spaces, and our school district's policy of obliterating single-sex spaces violates our rights. And then the more affirmative question of whether students or anyone has a right to single-sex spaces would have been directly before the Supreme Court, and the Supreme Court couldn't be bothered.
Very
Well,
frustrating
they
indeed.
go for the little boys.
So it seems like you kind of answered this. Lorraine had asked, to be clear, women in general would not be able to safeguard women-only spaces through the religious argument. It sounds like it would only be just for those specific spaces to which the case pertains.
It would be only to spaces that are maintained by religious people. So,
Mhm.
uh, I suppose a restaurant in Washington that's owned by Christians or Muslims or members of any religion who object to mixed sex bathrooms could maintain single sex bathrooms.
Mhm.
But a
But
restaurant
only
owned
such establishments. Yeah, most establishments that wouldn't apply.
establishments. Yeah.
Gotcha. Um, Judy had asked, in what ways might this case affect lesbians in particular?
Do you want to do that, Elspeth, or do you want me to?
Now I'm thinking about it. I think the thing that's interesting is it affects lesbians in that the way they took the legislature defined gender. First, it said it's sex discrimination against heterosexual, bisexual, homosexual, and then there's some other words and some ellipses and gender identity or expression. And as Judge Lee was saying, that's not how you read that. You don't read gender identity as one of those sexual orientations. It means something else if you look at the whole statute. So what you end up getting with this is the court saying, oh, yeah, gender identity basically, it doesn't matter what your sexual orientation really is because gender identity trumps everything. So where would you be able to say, I want a lesbian only space? Well, first we have to know what a lesbian is. We should define woman. Well, we know nobody's done that yet. So, the guys are going to show up and say they're transbians or whatever they are. Um, we've got to get a definition of woman first, because from that you can get a definition of lesbian. Um, Otherwise, nobody knows what a woman is. Well, then nobody knows what a lesbian is. Lesbianism disappears, homosexuality disappears, everything's gone. Sex is gone, everything. Just one big category for men.
The other thing I would say, how this case could specifically affect lesbians, is that the statute itself says you're not allowed to discriminate in places of public accommodation, which the spa is, on the basis of sexual orientation. That's great, right? Like, we don't want places of public accommodation to discriminate against lesbians or gay men. The problem is that then it goes on to redefine sexual orientation to include gender expression or identity. I think that if this spa which is female only, were ever to discriminate against a lesbian, I think she would have a perfectly valid claim of sexual orientation discrimination against this woman only spa because all women are supposedly welcome. And if the spa excluded a lesbian, she would have a perfectly valid claim of sexual orientation discrimination. But this case is so insulting to a lesbian's ability to bring that claim because this is a straight man.
Mhm. Mhm.
Yeah, so many layers of messed upness here.
Yeah.
Really, it's just I've been working on this since, well, before I retired, when I really started to see what was happening and started learning and researching and reading Kara's books and things. Those were my lifeline. Oh my God, there's another lawyer, smart lawyer out there who's thinking these thoughts and giving me answers because as you know, I was doing conveyancing and murders. So the straight talk on all that, we really need it. We really, really, really need it. I forget what I was talking about. So,
Well, thank you for saying that.
it's true, though. I was mailing it to friends.
That's great. Laura asks, do the panelists know if there are any other cases brewing that are similar to this one?
I'm not I'm not aware of any other cases brewing that have anything to do with, well, that's not true. There are a lot of interesting cases at the district court level that pertain to matters of sex and gender identity. There are a couple where the federal agencies have started to implement the early 2025 executive orders
Mhm.
by separating federal employees by sex. And some men who call themselves women are quite upset at having to use the men's room in their places of employment at the federal government. And they're starting to sue. And there are a couple cases like that at the district court level. But I am not aware of any other case anywhere that involves something like a nude spa. I mean, worth noting, one of the things that Judge Van Dyke talked about in his dissenting opinion to his opinion wanting to rehear the case by the full court, he talked about the We Spa case. And that's something that WDI USA had talked about in its brief too, because it's very similar. It was a female-only nude spa. In the We Spa case, it was the women-only section, whereas in Olympus Spa, it's an entire women-only spa. But the principle is the same. A man was allowed to enter the women's section of a nude spa, naked, fully intact, et cetera, et cetera. And that man was charged with 9 felony counts of indecent assault and acquitted on all of them.
Hmm.
But yeah, I'm not aware of any other case involving a space like a spa that's currently pending or percolating.
Yeah,
Okay. Well, oh,
there
go ahead.
may, there very well may be, but
Gotcha. I think this will probably be our last question. Chris asks, can women sue a state legislator or governor, say in California, for undermining women's sex-based rights through legislative laws?
um,
Is
you
that possible?
if you had a law that you were objecting to and you wanted to challenge it, and something actually happened to you, so you could show you were harmed, because we know how sensitive they are about that. Um, you could file a claim, but you're most likely going to get knocked out of court eventually on immunity, on political immunity, or uh, some kind of governmental immunity for people doing their jobs. Politicians, such as governors or legislators, have a very wide berth in what they can say and do politically without getting themselves in any trouble at all. So if they were doing it politically, no. If they were doing it as part of their job, maybe, but it'd be hard to overcome, because you'd have to show that this was so obvious and foreseeable that no idiot would do it. And unfortunately, we're past that. They've done it.
No
Irene,
shame.
I'm wondering if you want to end with what Beth has posted in the chat, because it's a nice little glimpse at some good news in all of this.
Yeah, and I was trying to access the X um, status, and I don't think I can't seem to get to it. It says the link isn't working, but um,
What Beth said?
the X post, you mean?
Yeah, but she also quotes it in the chat.
Oh,
Okay, yeah. She says, you think you've heard the last word in callous, self-serving, reality-defying luxury beliefs, but then a female legislator responds to a question about male sexual assault by saying how proud she is of the measures taken to make sure the sex offender's feelings aren't hurt.
But that the real exciting part was that's J.K. Rowling reposting Beth. So
Right, sorry. Didn't mean to bury the important part there.
oh, it's exciting.
That is
I
exciting.
want to know where Oprah is on this.
Where do you think?
I know. I know. They all of them, betrayals.
Mhm.
If you're my age, it's a betrayal.
Yeah. Okay, well, we are almost at the hour, so thank you all of you so much for coming and hearing these updates. I'm sure we'll have more to share again soon. I did want to make one last final ask for you all to donate to support our legal work, and I'll put that link in the chat one more time. Um, yeah, we are, again, as an all-volunteer organization, we really appreciate your support and your contributions, your questions, and we hope to see you again very soon.
I think